One of the biggest estate planning mistakes that I often see, and in this video, I'm going to be responding to a comment about somebody who's had a particular problem with this specific situation. That problem, that pitfall, is putting a child's name on a deed to a home that you own. First, to introduce myself, my name is Michael Pevney. I am an estate planning lawyer. I create estate plans for California families. You can follow me for more estate planning information, and you can ask a question in the comment section. That's ultimately what prompted me to create this video. So I'm going to read the comment for you. It says, my child is 48 years old and is on the deed to my home. Now he's trying to control my home. What can I do? So I'm going to give a little bit of a background here into why somebody would do this and what the options are in case something like this ever happens. So first, why do people do this? What's the reason for putting a child on the deed to a home that you own? It is an estate planning tool that can be an effective way of avoiding probate. Now, what is probate? Probate is the government-controlled, court-supervised asset distribution program, and if you die without a will or without any sort of a will or a trust or any sort of estate plan at all, it's going to have to go through probate. Where I practice in California, it can take a long time. It can easily take 1 to 2 years, possibly more, and it can end up being really expensive. On average, for a California homeowner, it can cost you, and well, it's really not you that's paying this, it's the people that you leave behind. It's the amount that they are not going to inherit, an average of about $30, $40, $50, $60,000 based on the value of the home and based on the value of the estate. So one way to get around this is to place a child, the person or persons that you want to inherit that home, on the deed to the home. And typically they would become joint owners, and that comes with a feature called a right of survivorship. So joint tenancy with right of survivorship. Essentially, that means that the last person living owns the home. So if it's two parents and a child and both parents pass away before the child does, the child simply owns the home. You essentially file a death certificate with the county, and that home is now titled in the child's name, and they can do whatever they want with it. So a lot of parents will put their children on the deed to the home because it will, and often does, avoid this probate system. But in doing so, putting a child on the deed can also give up current ownership to that home. So when somebody is a joint owner of the home, they can do whatever they want with their portion of the property. So it's would be referred to as an undivided portion of the whole. So if there's two people on the deed, it's an undivided half, three people on the deed, undivided third of that property. And here's what can go wrong. If the parents want to sell that home, they're going to need the permission and the signature of that child because they own a portion of that home, and they don't have to give it to them. They can prevent a sale of that home. They can sever the tenancy, meaning they can make it, instead of a joint tenancy, what's known as a tenancy in common, and break things up into a percentage. So the parent owns 50% of the home and the child now owns 50% of the home. And technically that child can sell their 50% of the home to whoever they want to. And now the parent owns that home with somebody that they didn't necessarily give permission to own that home to. They can take out a loan. They might be able to take out a HELOC or a home equity loan on the portion of the home that they own, and that is going to have essentially a lien on the entire property. So what happens when we put a child on the deed to the home is we give up control. There are also situations where maybe we need to use the equity, or the parents need to use the equity of this home to pay for things like medical expenses, to downside the home. This can be prevented by the child using the control that they now have in that home to prevent that, and to ultimately go against the parents' wishes. Now, usually the wishes are that the child inherits the home after the parents pass away. And typically that will happen, but a lot of people don't realize that they are giving up current control. Another reason not to put a child on the deed to a home is it leaves the home open to lawsuits, creditors, and possible divorce proceedings of the child. So even though the parents may not have signed a loan for something and their finances are great, but a child declares bankruptcy, that home, that portion of the home is going to be counted against them. If they are sued, maybe they're uninsured and they got in a car crash and there's $1 million judgment, guess what can be used to satisfy that judgment? The home that they are the partial owner of. And in some circumstances, even a divorce proceeding, if they split up from their spouse, that home can be used as an asset against them and possibly against you. What we really want to avoid here is even a potential forced sale of that home to satisfy some sort of a divorce split up of assets. So by putting a child on the deed to the home, we can face a lawsuit, a divorce, or a bankruptcy, and that home can be exposed to potential creditors. And here is a huge one: capital gains taxes. What happens is when we put a child on the deed to the home, it is as if the child paid for the home what the parents paid for it. And if the parents pass away and the child ends up selling the home, they're going to owe a significant amount, usually, of capital gains taxes. So let's say that parents bought a home 40 years ago, they paid $200,000 for it. Now, when the parents pass away, the home is worth $1 million. Now, if the child chooses to sell that home, it is as if the child bought the home for $200,000. They sell it for $1 million, $800,000 in gain. That is often taxed at around 20% or so. So we're looking at $160,000, if I'm doing my math right, in terms of a tax bill. If the child inherits that home by way of a will or a trust or some other way, after the parents pass away, there is what's known as a step up in tax basis. So instead of it being as if the child paid $200,000 for the home and sold it for $1 million, when the parents pass away, the child inherits the home. It is as if the child paid that $1 million for the home, the value of the home when the parents pass away. And if the child turned around and sold the home within a relatively short period of time, there is essentially zero capital gains taxes involved. That is a six-figure mistake that we often see happening just as a trick to avoid this probate process ahead of time. And so that is a huge one. So what do we actually do for the person who has already put their child on the deed to their home? What are the possible solutions here, and what can be done? Unfortunately, there is no perfect solution. We can't just take the child off the deed to the home. They have to agree to it if that were going to happen. So you can ask them to say, you know what? I really want to make sure that we're doing proper estate planning here in the best way, and let them know what the capital gains implications are. You should deed your portion of the home back to me. I'm going to put it in a trust, make you the beneficiary, or you become a beneficiary of the will. The home's going to go to you anyway after I pass away, and the home's not open to any sort of creditors of yours. So that's one option. They just give the home back to you. Possibility that could have property tax consequences depends on the state that you live in. So you're going to want to check with a qualified real estate or estate planning lawyer there. They can sever the home. We can talk about maybe the child just owns 50% of it and the mom now owns 50% of it, and not a perfect solution, but the parent can now control half of the home and the son can control half of the home. Also difficult to do, especially if one person wants to sell it and the other person doesn't want to sell it, and we have all of those issues of the title now being encumbered by two owners, and not a lot of people are just going to want to buy half of a house. Next, we can go to a court to force a sale. And that is oftentimes what ends up happening if there is a conflict between the two owners. One wants to sell, one doesn't want to sell, one wants to take out a home equity loan, the other one doesn't want to. A judge can force the sale of the home, then splitting the proceeds between the two or more owners of that home. That is oftentimes what does end up happening when there is a conflict here. That also means going to court. That also might mean hiring a lawyer, being additional costs to that as well. So the best thing to do might be to reach out to specifically a real estate lawyer, but those are sort of the three main options there. We can sever the tenancy, we can sell the home, we can hopefully ask the child to give the home back. So the much preferred solution to putting a home in a child's name or making them an additional owner or a joint tenant to the home, it seems like a quick fix, right? And it is, in the sense that it will not have to go through probate when a parent passes away. But there are so many drawbacks to it, from the lack of control to the opening up of that property to potential creditors, liabilities, bankruptcies, divorce, and then the whole capital gains issue, which is huge, especially where I live. And there are plenty of homes that were, the parents are original home owners. They bought the home 50 years ago. It's gone up 5x, sometimes 10x in value from when the home was purchased, where that capital gains issue is just a huge issue. So we want to typically, the preferred solution, and what I recommend for most of my clients who want to leave their home to their kids, is we create a trust, a revocable living trust. We place the home in the trust with the parent or parents in complete control of everything while they are alive. That does require filing a deed with the county land office, what we call the clerk recorder's office in California, and we make the child, or really whoever you want, the child or children, the beneficiary of that. And the benefits of that are, first, it doesn't have to go through the time, the hassle, and the cost of probate. Remember, we're often talking $30,000 to $50,000 or so. Second, you have complete control over the home while you are alive. You can sell it. You can take out a loan or a HELOC on it. You can downsize, live in whatever home that you want, or sell it because maybe there are healthcare needs or something that need to happen. Third, it is not open to any creditors of some future beneficiary, so that home is now protected from that. And of course, it is going to end up going to that child in the future, and they're going to benefit from that step up in tax basis. So there's not going to be a huge amount of capital gains taxes. So we went through a bunch of different issues going on. This is all in response to that comment that I got on a previous video that I put out there. Someone essentially saying, well, what do I do? I put my kid on the deed to my home. They want to control it. What can we do? And so there are only a few options there, and to some degree they can have control over it because they now own half of that home. So if you have any questions about this or anything else related to estate planning, please go ahead, leave a comment. You can follow me on whatever platform you're on. You just search my name, and my username is Estate Plan Lawyer. And if you live in California and it's time to get that estate plan set up, you can find a link in my profile or in the description of this video and set up a time to meet with me for free, California residents only. I appreciate your time and I appreciate your attention.